Have you ever wondered about the implications of the Corporate Transparency Act on businesses? Well, let's dive into its transformative journey, from its implementation to the recent court ruling. The Corporate Transparency Act, or CTA, was set in motion on January 1, 2024. It mandates smaller corporations, limited liability companies, and some other business entities to submit a beneficial ownership information report, also known as the BOI, to the Financial Crimes Enforcement Network of the U.S. Department of the Treasury, or FinCEN. The purpose? To identify and provide contact information for the individuals who either own or control the entity. This information would then be shared with law enforcement to combat illicit activities such as money laundering. Since its inception, approximately 500,000 BOI reports have been filed online on the FinCEN website, affecting around 32 million existing and most new businesses. However, a twist in the tale occurred on March 1, 2024. The Federal District Court in Alabama deemed the Corporate Transparency Act unconstitutional. This ruling was made in the case of National Small Business United v. Yellen, where an injunction was issued, staying enforcement of the CTA against the two plaintiffs, a single individual business owner and the National Small Business Association, a nonprofit organization comprising 65,000 small business owners. This court ruling has stirred a bit of uncertainty among businesses subject to the CTA, also known as reporting companies. Here are some key points you should be aware of. Firstly, if you were not a member of the National Small Business Association as of March 1, 2024, this decision does not directly affect you. FinCEN still expects all reporting companies to comply. Secondly, as anticipated, the Justice Department, representing the Department of the Treasury, filed a notice of appeal on March 11, 2024. So, this trial court decision is far from the final verdict on the CTA's constitutionality. Thirdly, the future remains unpredictable. Legal experts believe there are strong legal grounds to overturn the trial court's decision, but only time will tell. Fourthly, if your reporting company was established before 2024, you have until January 1, 2025 to comply with your BOI filing requirement. So you can wait until late 2024 to see the outcome of the pending litigation. Lastly, if your reporting company was formed during 2024, you have just 90 days after your incorporation documents were filed with the Secretary of State to file your BOI report. Waiting is not an option for you. In the meantime, New York has enacted its own BOI reporting law applicable to limited liability companies formed in New York or those registered to do business in New York. Other states like California are contemplating similar laws. To summarize, the Corporate Transparency Act has sparked a significant shift in the business landscape, with its constitutionality still hanging in the balance. Businesses must stay informed and be prepared for potential regulatory changes as the legal battle continues to unfold.